Good morning, good afternoon, good evening again to those of you who are joining us. We are very appreciative of your spending the next hour and a half with us. We, all of the international bar associations, employment law divisions, and sections of the international bar associations that are participating in this webinar are very pleased that you are joining us. We decided to collaborate with each other and form this very informal group during the unprecedented times in which we found ourselves last year, and realizing that it was easier to connect with each other, but also that we could mutually support and learn from each other. And the first topic in deciding what would we think would be of interest to our members was litigating in the era of COVID-19, as we all saw our practices change and have to adapt to the pandemic last year. So that is how we all came up with this topic when the chairs of these global bar associations met during the fall of last year. And that brings us to our webinar today, which we hope will be the first of many collaborations between our bar associations and other international bar associations that join our group. Today, we're going to go in a format that each speaker from each jurisdiction will speak about their jurisdiction. We recognize there are other ways to do this. We have 10 speakers, and we thought that this was a good, efficient way to do our very first webinar. As we do more webinars, we may change the format and go more to a question and answer format, or one where each speaker is reacting to the other speakers. But for our very first one, we decided to go jurisdiction by jurisdiction. And so we'll start by my introducing the chair or representative of the Bar Association, who will in turn introduce the speaker from their bar association. So we're going to go in alphabetical order in case anybody was wondering what the order is, except the American Bar Association will go last because I'm the facilitator, and with my good manners, I feel like I should go last with my bar association. So we will start with AIJA, the International Association of Young Lawyers, and Cato Arts will be introducing the Bar Association to all of you and the speaker from the Bar Association.
Thank you, Samantha. Hi, everyone. Welcome on my behalf as well. I'm actually one of the vice presidents of the Employment Law Commission, so I'd like to give the word to our president, Caroline Barbe, who is also on this call today.
Thank you, Cato. Welcome, everyone. I'm glad to have with us a member of our association. AIJA is the only global association dedicated to lawyers and in-house counsel under 45 years old. It has today around 4,000 members over 90 jurisdictions. And one of them has come to discuss the topic of today for her jurisdiction. It is Emily Svenseter-Jantorp, who is currently counsel at Vinge, which is a Swedish full-service law firm. She practices employment and M&A, and her practice regarding employment is both advising and litigating for employers. And so, Emily, I leave the floor to you to present this topic on the Swedish jurisdiction.
Thank you so much, Caroline, and thank you for inviting me. I think this is an exciting opportunity to talk with people from all over the world, and we get to start in Sweden, very much up north in Europe. And when it comes to disputes relating to employment in Sweden, these are handled by general courts. I know this is different from other jurisdictions, but that's how we have it in Sweden. And we have, the Swedish Labour Court as the highest instance. And the Swedish general court system has actually not seen that many changes during COVID-19. I don't know if you've heard rumors about the Swedish way of handling COVID-19 as such being a little bit different than others, this has also had an implication on our court system. And so the focus has been very much to keep it as much as possible to be business as usual. And this means that the courts have all remained open. Hearings have, as a general rule, actually been held at the court and with the participants present. Of course, there have been some adaptations to make the environment as safe as possible. There have been plexiglass, the rooms that are booked for the hearings are bigger. We have longer tables where the judges sit. And of course, limiting the number of people that can listen into a case. That's been a great limitation. But business has in many aspects actually carried on as usual. So the courts have not, as in many other jurisdictions, actually changed to a digital platform. And in practice, it means that the hearings in general have been cancelled more often, since there is, of course, an expectance of the physical presence, and that means that you need to be completely symptom-free. So the courts have actually leaned more towards cancelling a process rather changing it to a digital format. We have, however, since many years had the possibility to actually have hearings with a party on remote, and we have seen an extended use of this during this year. And also previously, it's only been acceptable to do this and be present remotely from a video link from another court. But now it's actually been possible to also be present via link from your own office, and in many cases, your home office, as it is right now. But still, the judges will be at the court's premises. So the courts have stayed open, and many courts have actually been able to handle more cases than usual, as it has turned out. I just look at the cases from the Swedish Labour Court as of today, and last year they delivered actually the same number of verdicts as they did on average the last 5 years. So it had kept up the numbers. I want to say, even though I say that generally it's handled by general courts, I want to say a few words on arbitration as well, because in some cases you have very senior employees, and in those cases you can have that the parties agree to handle disputes by arbitration. And generally, I would say that the arbitral proceedings have started to lean a little bit more towards the digital platform, but it's still very much in the beginning, and many cases are still handled in a physical format. And I know it was mentioned in the invitation that to give a few tips about how to keep the enthusiasm up from the judges, etc. So we haven't seen much of that. I just want to give one tip for me is, of course, to always check the equipment in good time and make sure that the camera is pointing in the right direction, because I had a counterparty that actually carried on an entire session only showing his stomach, and there was a glimpse between the pants and the shirt because he used his phone, and it was in the it was lying down instead of standing up. So always check so that you actually focus on the right things. But that's very short what's happened in Sweden last year. Thank you.
That was a very interesting story to end on, and a very good cautionary note. I'm not sure if everybody saw what we saw in the US. I think it actually went viral with the person who was appearing as a kitten because of the filters on Zoom. So definitely cautionary tales about using Zoom. Thank you for that. So next, we're going to move to the National Bar Association of Corporation Lawyers, and introducing the speaker will be the chair, Hugo Hernandez Ojeda. Hugo?
Thank you, Samantha, and hello, everybody. Good to be here with you. Thank you for the invitation. On behalf of the ANADE, which is one of the 3 law bars registered in Mexico, I'm very glad to present Rafael Vallejo, who is the chairman of our Labor Employment Committee of the ANADE here in Mexico. Just for your reference, the ANADE was founded in 1970. We have more than 1,800 members from companies and law firms. We are one of the largest bar association in Mexico. Regarding Rafael Vallejo, our chairman, as I mentioned it, he's partner of one of the largest law firms in Mexico, Chavez Ruiz and Samaripa. He's in charge of the labor employment practice of the firm, and he has a lot of experience in international matters, labor matters, and of course in litigation. Rafael is one of a good friend of us, and please, Rafael, go ahead.
Thank you. Thank you, Hugo, and thank you to the American Bar Association for this invitation. We are very glad to be here. I hope all of you are safe and well. And I'm going to talk about the litigation challenges that we have faced in Mexico during the pandemic. And as you know, since this started in many countries like in ours, there has been lockdowns, or there have been a lot of lockdowns in and out. And we depend on a code system from red to green, and in the middle we have yellow and orange. It's up to us because you normally, when you are on the street, you see the code light is green, yellow, or red. But when you have orange in the middle, sometimes it can be confusing also for complying with the lockdown regulations and so forth. The issue with Mexico is that we are in the middle of a change from our justice system. We have been working with a justice system that is composed of labor boards rather than labor courts. And this is hanging from the executive branch of the power. Now, a major reform was passed and enacted on 2019 for switching the labor board system to a labor courts system, and a new way of handling the litigation procedures in order for them to become more rapid, more swift for the providing of justice in the labor arena. This caught us in the middle because the change of the labor justice system is being ongoing since 2019, and it will end about in 2022 or 2023. So when the lockdown started, a lot of labor boards closed. They did not handle the litigation, and the hearings were postponed in a major way for about 2 months on the first lockdown. Then they resumed activities, but the problem with our system is that it's very formalistic. So if you file, or if an employee files a lawsuit, the lawsuit needs to be served at the domicile or at the address of the employer. And during the lockdown, there was no service process. So a lot of lawsuits accumulated during the lockdown because they enabled, the labor boards enabled a digital filing platform for lawsuits to be filed on a digital manner. But the issue was that there is a bottleneck because all these lawsuits have not been served yet. We have about, and the numbers have not been released, but the rumors are that there are more than 250,000 new lawsuits that have not been served by the system. And that means that all these litigation procedures have been postponed to the following years. And in Mexico, the problem that we have is that our justice system being so formalistic, it means that a litigation procedure can take between 2 to 3 years to be resolved, to be fully resolved. We also rely a lot on arbitration or pre-conciliation procedures, where you have employers and employees trying to reach out to certain agreements before they enter into the formal process and submit evidence and so forth. But even with this pre-arbitration or pre-conciliation procedure, we have not been able as employers to reach out to the litigation attorneys of the employees in order to try to reach out to certain agreements and to solve the disputes, because of the digitalization of the platform is not concluded. So the problem is that the budget from the federal government was allocated mainly to the new or to enabling the new justice system for 2022, and they had not many resources for enabling the digital systems. So we have now a bottleneck there, and the challenges are that we will have to change to the new system, but at the same time to serve all these lawsuits that have not been served and that are still pending to be notified to the parties, and not only that, on the upper courts level, we have a lot of remedies that are still pending of being resolved, or constitutional remedies, and even if the court or the Supreme Court of Justice have held certain digital or online meetings and for resolving certain issues, they have adopted the criteria that only the most important issues shall be resolved, and the other local or more, I would say, lower disputes in terms of amounts and in terms of importance are still pending to be resolved. So the challenge is big here. The lesson that we are seeing in this regard is that the governments need to really look forward to somehow enable better better digital platforms for litigating, and to get rid a little bit of the formalistic view of handling litigation. So that's our experience here in Mexico. Thank you very much.
Thank you, Rafael. Really appreciate your remarks. Next, we're going to move to AGI, the International Employment Lawyers Association, which is particularly near and dear to me ever since I spoke at one of their meetings many years ago in Milan, and had the pleasure of meeting Aldo. And so I'm glad that we are connected again here. And I will turn it over to Aldo Bottini to introduce AGI and the speaker from AGI.
Thank you. Thank you, Samantha, and good evening or good morning to everyone. AGI, the Italian Employment Lawyers Association, was founded in 2002 with the aim of setting up a community of employment lawyers interested in promoting employment law as a specialization, regardless of whether they assisted employers or employees. Now we have more than 2,000 members, which is almost all the lawyers practicing employment law in Italy. We organize a school of specialization for young lawyers and the local and national conferences where we can discuss, compare opinions, and share experiences, also with colleagues of our other jurisdiction, as Samantha well remember. Because we strongly believe in building a global community with all employment lawyers associations around the world, and this is why we are enthusiastic to be here today. But coming back to our activities, we are consulted on a regular basis by the government and the parliament on employment issues, and we are in constant dialogue with judges and courts. Since the beginning of the pandemic, we have been committed to making the continuation of the court activities possible, while protecting the specific features of the employment law proceedings based on oral discussion, unlike the general civil proceedings usually managed in writing. This is why in our dialogue with the Italian Ministry of Justice, we supported the use of remote court proceedings. But for what concerns this and other issues connected to employment litigation in this difficult period, I leave the floor to my colleague, Annalisa Reale, a distinguished member of our association. Please, Annalisa, the floor is yours.
Thank you very much, Aldo, and good evening, good morning to everybody. And I'm really glad to be here with all of you because I'm used to attend the seminar, the conferences of the American Bar Association. I have many friends here and prospect friends, I'll select this. So it's good. Thank you, Samantha, for organizing this so that we can share our knowledge, and hope to see you next time and we can repeat our conference in Milan. We hosted this 2 years ago. And Aldo, that is a phenomenal chairman of our association, already introduced you to our daily work, so of employment association. And I will actually focus in a few minutes on three main aspects, two questions actually. So the first one is, what was the impact on the daily litigation? So what happened on our court proceeding under the coronavirus timing? The second one is any impact on the matters, meaning did we change? I mean, how was the litigation? What about was the litigation, the matters? And the third and last point is the future litigation. Can we foresee any change or any impact in the future lawsuits that are going to come in the next months? So starting from the very first one, that is the impact of the coronavirus on the court proceeding, the labor employment trials. What happened in Italy? I'm aware that, of course, that Italy has been widely impacted, unfortunately, in the first round of the pandemic, was one of the first countries to be severely impacted. So we had a serious lockdown. So differently from Sweden, we didn't have a lockdown. Italy locked down last year in March for a couple of months. So our trials, our court proceeding, they were suspended. So the deadlines, they were suspended, but this was on the very first emergency cases, the emergency basis, sorry. But then after this, for May, we started to again have a routine of employment litigation, but rules, they changed. So we had first tribunals, courts in Italy, adopting protocols. Then we had a provisions from the government, so that actually we switched the trials and the court proceeding and employment law to remote hearings or managing of the employment cases through a written proceeding. And actually, so it was up to the court to decide, in lieu of having normal trials, physical presence, whether to switch on the remote hearings or on the written exchange of briefs. How did it work? I don't have one response only, because our lovely country is pretty different from north to south. If you had any chance to visit Italy, you may know that despite the territory is not as big as the US, but the response is very different. And so in some courts, local courts like Milan, remote hearings, they were the prevailing way of conducting employment litigation. So we went remote for most of the trials. In some other local courts, like in the center of Italy or even to the south, lovely place. However, judges, they opted to keep it physical or for written kind of management of the proceedings, which actually we like less. Why we like less? Because actually, as Aldo was anticipating, the employment litigation in Italy is mainly oral. It was conceived to be fast in order to keep justice in a quick way. This is actually what is in the roots of our special employment law proceeding for cases. And so remote hearing, in a way, was back to the future, because it needs to be oral, and it needs to be front. However, as I say, the alternative for the judges was actually to go for the other way. There was a written exchange of briefs, and in many courts we were there. So to close this point, I would say that what we learned is that we can have a lot of remote hearings, we can have remote work, and it is efficient. Of course, depositions are not, but I guess we learned that we can do part of our activity really remote. So let's say if with the improvement in technical equipment and the attitude of judges to be technological, we can get this in a new normal also to normal regular use as an alternative. Second point, marchable litigations under the COVID. I tell you that we didn't actually had any litigation, or not any, but a few litigation on dismissals, because in Italy we had a ban to dismiss. This is very unprecedented around the world, I understand. But in Italy from last year, 1 year now in March, it is forbidden, there is a ban to have redundancies. So you cannot restructure, you cannot lay off people for redundancy cases. This is very hard, right? Because our companies, corporations, well, we advise you, friends, and say, can we dismiss the people? No, you can't. This is because the government funded a lot of stimulus, a lot of furlough schemes, and the government said, we pay the employees suspended, so you don't dismiss. This is why we didn't have so many, of course, urgency matters about dismissals. So we had some litigation about entitlement to remote work, because in Italy it's not a right to go remote work, only for several special categories like disabled people or attending, family care. Otherwise, it's not a right. You are not entitled to be a remote. We have some cases about wearing masks, but I would say that the main concern was about security at workplace, health and safety matters, and contagion at workplace. And this leads me to the final point, that is the future. I would say that talking among us, community of employment lawyers, this in Italy is the most worrying concern for employers. That is, what is the liability? Is the employer liable, and to what extent, for COVID infection at workplace? And this is very worrying for employers, for board of directors. We'll be advising, because for accident at work in Italy, we have civil and criminal liability as well. So the point is how to protect, how to ring fence companies and board of directors from any liability with this. And prosecutors can be in. And to have a shortcut, I would say that actually sticking to protocols, to the rules that from time to time have been enacted, can help employers to keep the liability out of the door. But this is what we see in the next future as potential increase in litigation. And so is the COVID professional sickness? And how can you prove that you got sickness at work, right? Because this is actually not a professional risk. COVID is in the restaurants, in the tube, if you take a bus, if you go on a crowded place. So I would say that for us in the litigation, what we expect is to face this. And as the last point, we had, for instance, yesterday, a release of our National Health Security Agency that say that if an employee refuses to be vaccinated, is not going to be protected from the insurance. So the last front of it is vaccination. So we will face probably a litigation about vaccination. So is there a duty? Does an employee has the duty to take a vaccine? If he says not, is he liable personally vis-a-vis other employees? Can be dismissed, cannot be dismissed. So I believe this is the future litigation on the coronavirus in the next months. Thank you very much for all. And Samantha, you the floor to continue this discussion. Thank you.
Thank you so much, Annalisa. And interesting sort of the way you ended speaking about the vaccines and who needs to get vaccinated, et cetera, because our informal group of chairs and representatives have actually been discussing having another webinar solely dedicated to sort of returning employees to work and the vaccines and what employers can require, et cetera. And so we actually are thinking about that as employees and employers around the world decide, how to implement that, and we have to give advice on those issues. So more to come on that particular topic, and thank you for teeing it up for us today. So next, I'm going to turn to BRAC, the German Federal Lawyers Association, and Marc-Andre Gimme, the chairman of the association, will introduce their speaker. And I thank Mark for being on our little subcommittee that helped put on this webinar today. Mark?
Thank you very much, Samantha, much appreciated. I'm Marc Gimme, and the chair of the Section Labor Law of the Federal Bar Association here in Germany. I'm a partner at Teller Wessing as well. The Federal Bar Association is an umbrella organization representing the interests of 166,000 lawyers in Germany with about 83 million inhabitants. 11,000 lawyers are so-called certified and registered specialist lawyers for labor law. The labor law section's tasks are, in particular, to prepare statements on new laws and expert opinions on individual professional policy issues for the board of the Federal Bar Association. Committee members frequently participate as experts in hearings at ministries or in Parliament. Today, I'm pleased to introduce to you a long-standing member of the committee as your speaker. Dr. Gerland Wiskirchen is a partner at CMS in Cologne. What else can I say other than Gerland is simply an outstanding international recognized expert in labor law. And I'm very much looking forward to her speech. Thank you so much. This is up to you, Gerland.
Thanks, Mark. You see my sweatshirt and myself are blushing now. No, I'm very pleased to explain a little bit where we are standing in Germany, but most of what I'm saying is also, I think, true for continental Europe. Let me say to put the lay of the lands here, what is the striking difference between the European litigation system in employment law and the US system. I think that helps a little bit to put it in context. I mean, we are not a civil, we are a civil law system, apart from the UK and Ireland. In general, we do have specialized courts in continental Europe, so specialized for employment law. We don't have any administrative proceedings or agencies in general. It's more a normal litigation system. We don't have jury trials, we don't have discovery, we don't have arbitration, we don't have class actions, and we don't have punitive damages. You might think what we are doing all day long, but the laws are pretty strict at the same time. Because we don't have employment at will, we have a high degree of employment protection. You need to have a reason in most continental European countries in order to terminate. And that is what most labor courts are circling around. It's in France, for example, 80% of all court decisions circle around the question of unfair dismissal. Same applies to most of the other continental European countries. And as we don't have punitive damages, we do have reinstatement claims. So you would say it's an unfair dismissal, we would like to have reinstatement. And you can imagine that there is a sort of, the principle of urgency is important. And when we had the lockdown, the legislator was very much concerned that this question of reinstatement would not come into play anymore because there would be procrastination. And in average, one can say in most countries, the typical first instance would be around up to 6 months. That's very short if you compare that with US proceedings. In Germany, it's even shorter. The first instance is on average 3 months. So everything is geared to either can the plaintiff go back into his job or he will be dismissed with a severance pay. So this principle of urgency was the main reason why the legislator thought about, okay, what can we do in order to prevent a shutdown of the labor court system a year ago. And while we had a statutory provision in Germany that allowed for video conferencing for almost 20 years now, which has never been used, at least to my knowledge, a special provision came into place about a year ago saying that courts shall allow video conferencing also for the lay judges that are involved. That was the law. The reality, and Mark, please chime in if you had a different experience, I think was disillusioning, so to say. And we shouldn't have been surprised by that because we had introduced a sort of e-certifying system when it came to letters to the court. We were supposed to do that by email and certified signature 2 years ago. And every law firm had to put up a lot of money in order to put that system into place. But the courts decided they just buy printers. So everything is now being emailed to courts, but the courts then print it out and put it in paper. So expectations weren't that high. And I think we can say nowadays that after a year, not that many video conferencing litigation took place in the last 12 months. I just had a sort of mass litigation of 60 proceedings. And one of the 60 is now on Zoom conference, the rest not. What is the reason for that? First of all, I think in the first months, people were not sure about data privacy issues. They had concerns about that Zoom and the like would save all the data in the US, and you know what the problem about that is. And then some judges shied away from the technical issues. And in practice, I think it's just a matter of hardware and software that many courts are just not equipped with video cameras, and not many judges want to use their private laptop in order to facilitate proceedings. But probably the problem also sits in front of the screen and not only is based on budget restraints. So one can say in summary, digitization in labor courts has not arrived yet. The provision I was talking about will come to an end after COVID-19. We will probably go back to the old system of having presence court proceedings. We do have other things like masks and plastic screens. I think that goes without saying. But let me end with something where I think it really helped in the past. And it's not about court proceedings, but Mark and I and all other lawyers doing employment, they also are labor lawyers. And we do negotiate with unions and works councils a lot by video conference. And that's a great success. That has really changed the world. And I would say at the moment, the majority of these negotiations really take place by video conference. And let's see where this ends in the near future. But I think that has given a push. So by having said that, thank you very much for listening. I'm happy to answer any questions.
Thank you, Gerland. Appreciate your remarks, and good to see you as always. And to Gerland's point about questions, please feel free to put your questions in the Q&A. We will be taking questions at the end of everybody's presentation. So thank you for putting your questions in the Q&A, and we look forward to seeing them and addressing them. Next up is the Employment Law Association of Ireland. And I'd like to introduce Anne Lynn, the chair of the Employment Law Association of Ireland, and also thank Anne Lynn for serving on the subcommittee that put together this webinar. Anne?
Thank you, Samantha. Hello, everyone. As Samantha said, I'm chair of the Irish Employment Law Association. The association was formed in 2010, and really our purpose is idea and information sharing. Its members include solicitors, barristers, but we also are broader than that. We would include union members and HR. Traditionally, we would have had in-person seminars and networking events. And of course, unfortunately, we cannot have those now. But the silver lining is we are participating in webinars such as this, where we've really reached out beyond our membership to other countries. So that's been a great benefit to us of COVID. So also thank you to Samantha and the association for facilitating this. Our speaker will be Peter Murphy. He's a former chair of the Employment Law Association and a partner in McGuinness Dunn, a boutique employment firm. So Peter, over to you.
And thanks Samantha for arranging this, and thanks to all of you for logging in at whatever time of the day it is for you all and giving up your time. What I'm going to try and do, if this isn't a complete oxymoron, is look at the last 12 months in 5 minutes, looking at four general headings. So what I want to look at is, I suppose, the initial response of the bodies here that we have in dealing with employment law disputes. Secondly, look at, we've had a piece of legislation enacted and another couple of pieces of legislation promised. So I want to look at those. I want to then look at the impact that those changes have had in practice and how practice has actually evolved and what is happening. And then fourthly, and briefly look at the future. Just for context, in terms of our systems in Ireland, we have, since 2015, we have two bodies that deal with statutory employment law claims. They are the Workplace Relations Commission, which is the first instance, deals with all first instance disputes. Hearings are held in private. by one single adjudication officer who may or may not be legally qualified, and then on appeal, the Labour Court. The Labour Court consists of 3 members, and there's a de novo appeal from an EWRC hearing. You can appeal from the Labour Court to the High Court on appointed law, and the High Court is one of the superior courts in Ireland. So that's the context. Those are the bodies I'm going to be speaking about. In terms of the initial response, I suppose, like everyone, like everyone throughout the economy, throughout the world, there was shock last March and April, and things pretty much ground to a halt. The WRC and the Workplace Relations Commission in April of last year announced that they would engage in an extensive consultation programme, and we, as the chair of ELI, engaged in that, and that went on for a number of months. That resulted in remote hearings at the WRC from July of last year, but it was only certain type of complaints, so payment of wages claims, Organisation of Working Time Act, Terms of Employment Information, the most kind of basic claims. So it wasn't unfair dismissals, it wasn't anything that was contentious. The Labour Court were a little bit more, I suppose, proactive, and they had announced as early as, well, early, it was still a number of months, but earlier than the WRC in May, at the beginning of May last year, they announced that they had put in place technology and identified cases which would be suitable for remote hearings, and they were hearing remote cases from May. In terms of the superior courts here, the High Court, the Court of Appeal, the Supreme Court, they have an inherent jurisdiction to hold cases remotely, and they use that. I know from personal experience, I took a judgment of the High Court last, I think it was May, where ordinarily solicitors, barristers, registrars, clients would all go into court, they would all sit there. That was all done remotely through the registrar. The costs application would usually be dealt with then on a separate day after judgment is given. That was done at direction of the judge remotely as well, and it was all very efficient. I think that the Chief Justice we have at the moment is quite progressive, and even before COVID had spoken about the need to modernise our courts, make better use of technology and how the courts function. So I think that was probably going to come anyway. The second point that I want to turn to is the legislative change that we have had. You know, I spoke there about the WRC and the Labour Court only being able to deal with certain cases. So there was a recognition that, you know, more needed to be done and legislation needed to be put in place to allow that to occur. So last August, an act, the Civil Law and Criminal Law, so it covers both Miscellaneous Provisions Acts, was passed, and that act places remote hearings on the same footing as a physical hearings in physical courtrooms. Parties can oppose a remote hearing, but ultimately the court will decide if it's fair to all the parties and in the interests of justice to proceed with a remote hearing, and that's where we're at the moment. It also allows for electronic filing and other things. In relation to the specifics of the Workplace Relations Commission and the Labour Court, importantly, the Act allows the Minister to identify and designated bodies which can hold hearings remotely. And that was what was done in September in relation to the Workplace Relations Commission and in November in relation to the Labour Court. So that has meant that the scope of the hearings that they can hear has been broadened. So it's not just the more straightforward claims, it's now unfair dismissals and other claims. That's enhanced their ability to deal with things while they have to deal with things remotely. In addition, and interestingly, in terms of the legislation that's proposed, the government last month announced that it was their intention to legislate to give people the legal right to ask their employer to allow them to work from home after the pandemic. So that is something that they're committed to. They're also committing into that, you know, that'll be across the board, public and private. In the public sector, they have said that their aim is to have 20% of public servants working permanently, or more permanently, I think was the wording, by the end of the year. So I don't know how that's all going to play out in practice. It's going to be a right to request as opposed to an absolute right. So, you know, at the moment, I have a right to request when I take my annual leave, but ultimately my employer can say, well, you can't take. So we'll have to see, but it is going to be governed by a code of practice that's to be developed by the WRC, and rights will be, any denial of the request will be actionable as a case in the WRC. The minister who is our former Prime Minister, who's now the Minister for Enterprise, Trade and Employment, he has also stated that legislation will be introduced to allow those who are working from home a right to disconnect. So we got a coup this year in terms of our AGM. The Minister has agreed to be our guest speaker at our forthcoming remote AGM, so we get a chance to put all these questions to him at that stage. In terms of how it's worked in practice, the civil courts have continued to hear employment law cases. There was a judgment just last week of the Court of Appeal. That's the court that hears appeals from the High Court. There was a decision last summer of the High Court of an employee who had been dismissed during his probationary period, and he secured an injunction restraining the dismissal. Last week, the Court of Appeal overturned that decision. In December of last year, there was actually it started off as an employment law case, an unfair dismissal claim in the WRC, but it's gone on since then, and it's now in essence a constitutional challenge to the constitutionality of the WRC. That was heard remotely by the Supreme Court last December, and judgment should be given in that shortly. And in terms of the WRC and the Labour Court, there seems to be some IT issues that maybe slow down that process. Cases aren't heard as quickly, but interestingly, there was an interesting decision earlier this month from the WRC. It related to an employee who, in the first lockdown, had resigned her employment, because she said her employer just flat out rejected her requests to work from home, and she was found to have been entitled to resign her employment and entitled to compensation. So we are starting to see those COVID-related cases coming through. In terms of what's happening in practice, I think someone mentioned earlier on about, we're seeing other ways to resolve issues, because there are obviously delays, and it isn't the same as it was before. From personal experience, and I suppose anecdotal evidence speaking to colleagues, I think mediation is certainly increasing. I've done a lot of mediations in the last number of months, and when there is, slow and blockages in the court system, I think that is going to happen. In terms of the future, I think it'd be very foolish for anyone to try and predict anything about the future after the last 12 months. But in terms of employment litigation and where it will go, I think remote hearings, or some kind of remote hearings, are going to be here to stay. There have been a couple of cases in the High Court recently where people applied to have adjournments and didn't want to go ahead with a remote hearing and wanted a physical hearing, when we're currently in a level 5 lockdown that's just been extended this evening for another month. But the judges have refused those applications, with one judge commenting that it's, the cases that he had used in terms of dealing with them remotely, the technology ran incredibly smoothly, and he also said, we are not Luddites and we should welcome and embrace the existence of this technology. So if you have buy-in like that from judges and lawyers, I think some kind of remote hearing is probably here to stay. Thanks, Samantha. I'll hand back to you.
Great, thank you, Peter. It's really just fascinating to hear how this is impacting all of our jurisdictions so differently. I'm really glad that we put this together. I'm certainly learning a lot as I listen to all of you. So next up, we have the Employment Lawyers Association, and it is chaired by Marianne Bloodworth, and the chair of the International Committee is Kathleen Healy. So I turn it over to Kathleen.
Thank you. Or shall I introduce, just to explain a little bit about ELA? Hello, everybody. It's lovely to be here. As Samantha says, I'm the chair of ELA. In my day job, I'm an employment law partner at Deloitte Legal in London. And just to explain a bit about ELA, we have been going for nearly 30 years. We have 6,000 members, and that includes solicitors and barristers. And we are a membership organisation run by members, for members, and all largely volunteers. And we have two aims that we always try to achieve in the work that we do. We are apolitical, and that's very important. But what we do for our members is promote the best practice of employment law and also support the work and represent the interests of UK employment lawyers. And as Samantha says, we are supported by committees, so I'm delighted that Kathleen is here from our international committee. And our speaker today is Dia Sengupta QC, who is a barrister from Blackstone Chambers, a long-standing friend and supporter of ELA, and very well known in the UK for her superb litigation skills, in particular in complex and significant high-value employment litigation. She's a regular speaker and author, and she's also chair of an employment law bar association in the UK as well. So with that, unless Kathleen wants to add anything, I'll hand over to Dia.
Thank you very much, Marianne, and thank you very much to Kathleen and ELA for inviting me to speak. Thank you also, Samantha and the ABA, and to all of you speakers. I've learned so much already this evening. I thought I would speak about challenges for the advocate and some specific tips on conducting remote hearings. And I thought I'd start by talking about how things have changed from my perspective. As Marianne explained, I practice in England, and it sounds as though we are one of the jurisdictions in which courts have moved to video hearings over the last few months. The last time I was physically in a court or tribunal was last March for a 3-week trial. All of my hearings since then, of which there have been many, in almost every level of court, the Employment Tribunal, the EAT, the High Court, and the Court of Appeal, has been conducted remotely using a variety of video technology. Now, that's not to say that is everybody's experience in England. Some hearings have been taking place in person at different times during the course of the pandemic. At the moment, most hearings are taking place via video. In terms of challenges for the advocate, of course, there are many. Last March, it was really all about the unknown, as many of you have described. The key challenge was not knowing whether it would be possible for a hearing to go ahead or whether it would be postponed. Would it be possible to have hearings online? When? For example, the Employment Tribunal did not yet use video hearings. Other courts were using technology, but it was all fairly new. By way of example, the tribunals at the Employment Tribunal pretty much had to cancel all trials between March and September of last year in order to focus on transitioning to a new cloud video platform. Other challenges: what platform would be used by the court? Would it work? Last March, we didn't even know what to wear, where we expected to wear wigs and gowns for online Court of Appeal hearings, for example. The current challenges for advocates and our clients are similarly unknown about the future, whether or not hearings can go ahead online or not. Very few hearings are taking place in person. Alternative is a postponement very far into the future in some cases. For example, I'm due to start a 2-week whistleblowing trial next month, and we've recently been informed that if it can't go ahead in the current dates, it will be relisted not before next June, which is obviously very difficult for litigants as well as the lawyers. In terms of challenges of remote hearings, there are obviously many, but some examples. Does the judge want a hard copy of the bundles? How can those be prepared? Where should they be sent? To the court, to homes? What about lay members? Do they have the technology, the screens required? Making sure that witnesses have all the technology that they need. Taking instructions during the course of a hearing. The absence of the usual interactions with your opponent before and after court and during breaks that can be helpful to narrowing the issues. Reading the room during a hearing, whilst also following your notes in the bundles and looking into the camera. It's not easy to build a rapport with a judge over a screen. It's not easy to see how a judge is responding over a screen rather than in a courtroom. Some tips briefly on advocating effectively for a remote hearing. Much of it is about preparation in advance, assisting, instructing solicitors to prepare a bundle in a helpful way. What are the key documents that are needed? Contacting your opponent in advance, seeing if you can narrow any issues. Making sure that you have a useful method of communication with your solicitors and clients during the course of the hearing that is spontaneous. Checking that there is no bar on witnesses giving video evidence, as can happen in some jurisdictions. Making sure witnesses understand the process and the solemnity involved in giving evidence, even via video from home. Making sure they have all the right equipment. Making sure that they have the right documents. There's the usual preparation that one has for the sorts of video meetings we're all used to doing. Making sure that all the connections work, restarting computers in advance, checking that notifications are all switched off. But those that are specific to advocacy, multiple screens, making sure electronic bundles match hard copy bundles so that you're all looking at the same page, making sure that you can make the best use of written advocacy by trying to persuade the judge in advance of the hearing, because it may well be that your time is shorter during a video hearing than it would have been in person. So skeleton arguments and written advocacy is all the more important. During submissions, it's important to pause more, I think, during remote hearings to give the judge the opportunity to interrupt, ask questions during submissions. Another tip is making sure that witnesses are not receiving emails or WhatsApp messages whilst they're giving evidence. That can be an unexpected development. In terms of the future, I've been very impressed by the speed at which judges, barristers, solicitors, and our clients have risen to the challenge of embracing video technology. I think it's a good temporary alternative. I think it will be here to stay in some respects, but hopefully only for short, straightforward case management type hearings. I, for one, am very much looking forward to going back to conducting trials and other substantive hearings in person soon, I hope. Thank you. Thank you, Samantha.
Thank you very much. Thanks very much for your remarks. I hope soon as well, for sure. So next up, we have the Employment Lawyers Group of Northern Ireland, and I'm so impressed that we have two of the groups from Ireland and Northern Ireland, and the chair of the Employment Lawyers Group of Northern Ireland is Orla O'Neill. Orla?
Thanks very much indeed, Samantha. So wherever you are in the world today, I want to say hello to you from Northern Ireland, and I'm just really delighted to participate in this roundtable. And while Samantha, you were talking about the differences between the different jurisdictions, I've been really struck by the common themes that are running through and our common experiences in this global employment law world that we live in. So as Samantha said, my name's Orla O'Neill. My main role is partner and head of the employment team at Carson McDowell in Belfast, but I'm honoured to be in my second year as the chair of the Employment Lawyers Group of Northern Ireland. We have been in existence for over 25 years, and our members are all practicing solicitors or barristers who specialise in employment law, and they come from representing both employers and employees. We have a really active committee of about 12 lawyers, and our main focus before COVID was providing monthly seminars to our members on topics of interest, and also to liaising with government departments, etc., on new legislation. But like all of you, our focus has had to change during COVID, and the committee's main focus really has been in engaging in a constant dialogue with our employment judiciary, just to ensure that the interests of our members and our clients are being properly represented, during these really difficult times. I'm delighted to be joined today by Ryan Cushley. He's one of our most active committee members on the Employment Lawyers Group in Northern Ireland. He's a practicing barrister, and he's one of the most familiar faces in the tribunal. And he is going to provide our insight into employment litigation during COVID in Northern Ireland. So I'm going to pass over to you now, Ryan. Thank you.
Thank you, Orla, and thank you very much to the ABA for hosting this very interesting event. I suppose by way of background, Northern Ireland is a very small jurisdiction. We have only 1.8 million people. There is one building devoted to employment tribunals for the whole country, located in Belfast, and we have only 9 salaried full-time employment judges in the jurisdiction. So on the 27th of March last year, the tribunal building closed, and it literally closed and didn't reopen at all until early July. And when it did reopen, it opened in only a very limited capacity and with only very limited staff and no hearings. Cases began to be case managed again remotely by telephone from early August, but it wasn't until the 12th of October that we started to see hearings take place again in Northern Ireland. And the number of hearings that did take place were extremely limited. I could literally count on one hand the number of hearings that were taking place each week in the whole country. And that includes preliminary hearings as well as final hearings in cases. A risk assessment had been undertaken in the tribunal building, and that allowed for only 3 out of 10 available hearing rooms to be used. And the number of people who were allowed to be in each room was significantly limited. If there were solicitor and barrister for the claimant and respondent in a case, that took 4 out of the room, which left space for only 7 other people. You know, I did act in hearings in the tribunal from October, and we'll talk about what's happened with those hearings. And I must say, I always felt it was a fairly safe environment. Social distancing was quite strictly enforced, and use of face masks was encouraged and so on. In fact, the tribunal building even had a sort of one-way system, so you wouldn't come face to face with someone in the corridor coming towards you. The hearing rooms, you know, were fully adapted to be compliant with that risk assessment. But aside from those measures being in place, I actually thought that the conduct of hearings was pretty normal. There weren't really any changes from what we would ordinarily see. I thought the key difference really was the limited number of hearings that were taking place, and as I say, it was extremely limited. Unfortunately, in January, on the 19th of January of this year, the tribunal building was shut again. And the present position is that the building is shut until at least the 1st of March and will only reopen if it's deemed safe to do so, which is quite an ominous note for the presidential guidance to sort of end on. But there's been no information given publicly really that points towards why the building has been shut. You know, at present, there is some limited case management going on, but there are no final hearings at all. So, you know, I must say, against that background, if I can just say that I don't think you can overstate the impact that COVID has had on employment practice in Northern Ireland. Business has been disrupted to a really fundamental level. You know, in the past 11 months, we have faced 7 months where there have been not one final hearing taking place, and 4 months where only a very small number of final hearings have taken place. The backlog of cases in this jurisdiction is absolutely enormous. See, the BBC reported last week that it now stands at, I think, about 93,000 cases. You know, bearing in mind this is a jurisdiction of only 1.8 million people with a judicial complement of 9, that is a tremendous backlog, and it's difficult to see how that backlog is going to be tackled in the current sort of environment. Cases that require a full hearing, a final hearing, are presently being listed in June of 2022. And I think it seems likely that within the next sort of few weeks, or certainly within the next month or two, you're going to be looking at a hearing date into 2023. You know, I think the primary sort of contributing factors have been twofold to the situation in Northern Ireland. The first, I think, was that the tribunal's building seemed to be particularly reliant on physical papers, meaning that when the building shut, so did access to the files. And with access to the files gone, that effectively meant that no business could be conducted by the admin staff or the judiciary remotely. The second issue was I think almost a complete lack of technology in place that would allow for any form of remote hearing. And that was despite our legislation and our rules for the tribunal permitting remote hearings. So there's no technology in place, and we're assured that this is now being installed. And hopefully that will allow some degree of a return to normality and that hearings will be able to resume soon. So I think from Northern Ireland, perhaps a different story to some others that maybe are on the brighter side, but we've got a story of a standstill, a complete standstill, followed by, I think, a degree of improvement. But most recently, from January of this year, an almost complete regression to a standstill again. The only thing is, hopefully we do see some light at the end of the tunnel if the remote hearing solution is installed and if it works well. And I think hearing from some of the others, particularly from DIA, as to how remote hearings have worked in other jurisdictions, it does give me some hope that we may see a return to some degree of normality fairly soon. So thank you very much, and I'll hand back to Samantha. Thank you.
Thank you very much, Ryan, for your remarks. So next up is the International Bar Association. And here from the International Bar Association is Juan Bonilla, who is co-chair of the IBA Employment and Industrial Relations Law Committee. And he will be introducing the speaker and the IBA to all of you. Juan?
Thanks very much, Samantha, and thanks very much for the American Bar Association for making this initiative and putting all these different organizations together. It is absolutely a pleasure to represent the International Bar Association here on that extremely interesting session on what we call virtual litigation. On our side, just let me introduce Bikram Shroff, our speaker. Bikram is an officer of the Employment and Industrial Relations Committee and has been an officer for a number of years. He's based in India, so he will be very much pleased to give us probably a different perspective on how virtual litigation works on the employment context. Bikram is partner and head of the employment team at Nishi Desai Associates. He's also a very good friend, not only for me, but also for many of the attendees of the session. So I'm very pleased to have Bikram here on board on that session, and I'll hand over to him.
Thanks, Juan, and thanks so much, Samantha, for getting us all together. It's been a very interesting discussion so far. Just to kind of give you the perspective from an Indian law scenario, and to be honest, it's almost 11:40 p.m. for me here, so it's better late than never. And I'm pleased to be sitting late and joining all of you today. Litigation in India is never ending, right? It takes years and years for cases to go through various courts and finally to be resolved. And in fact, it's more a test of patience, and adjournment is a way of life for all of us. In fact, we also we often come across cases in India where the cases that go through various courts and eventually is finally resolved by the Supreme Court, the employee has already retired and probably does not have any sort of working life left. So it's not unusual to go through those kind of situations and come across case laws where the case might have started about 20-30 years back, and you're finally seeing judgment. But the fact of the matter is you can't even reinstate the worker because he's already crossed the retirement age, and that's really the sort of reality in India. And in fact, on a lighter side, we do joke around with friends and colleagues that one of the reasons that we in India believe in reincarnation is thanks to the never-ending litigation. And sometimes we feel that one life is not enough to conclude the case, and thanks to the COVID lockdown, things have been further delayed. We already had a massive load of cases that were pending, and COVID has basically added to that pile. So the situation has got worse. But luckily, as we went into the COVID lockdown sometime in mid or late March last year, the Supreme Court was quite quick, and in about 3 days thereafter announced that they will be introducing e-hearings, electronic hearings, but will be taking up only urgent cases. So those urgent cases that were kind of sensitive, involved national interest or COVID-related pandemic issues were basically being taken up by the court online. There were no physical hearings happening. And the Supreme Court also passed orders extending the limitation period for petitions and applications and suits to be filed, something that was a good development, given that if you cross the limitation period, then you can no longer apply for the case. So that was a positive change from the Supreme Court. It also has in due course launched a e-filing system, so that you can file your cases online and you don't really have to go physically. So hopefully it kind of reduces all the paperwork around that. And also there were certain standard operating procedures that had come over time from the courts. But I think the general sort of feeling was that it is not very efficient in litigating online. And obviously as litigators, there is a lot, it's a whole different world when you're there in the court as compared to sitting at home and trying to argue your case. So we did face challenges, and clients were frustrated with the, how slow the system was, and, things kind of kept getting adjourned. And that also drove some clients to actively pursue settlement or sort of closure, rather than waiting forever to for their case to come up and be heard. Some of the important cases that came up during the COVID, especially from an employment law perspective, included one case in relation to the government orders to employers that they should not be cutting deducting wages as a result of COVID lockdown. That case, there were quite a few writ petitions filed in various courts in relation to those government orders, and these were orders both at the national as well as the state level. And employers were very upset and angry with those kind of orders, as to how can the government prescribe these orders when it's really a private employment arrangement. And those cases were taken up by the Supreme Court through the writ petition. And that was one of those bigger cases. And the Supreme Court passed an award that, yes, employers can enter into a negotiation with their employees and reduce wages. I think the question was about 60 days of lockdown when employers had to completely shut down. And that was one important area that the Supreme Court was quite active about. One other area that came up was, the Supreme Court laying down principles in relation to contract for service and contract of service. Again, we've seen those cases come up in various countries, including in India. And the Supreme Court basically said in that case that there is no one test which can universally apply to yield the correct results. And the determination of whether it's a contract of service or contract for service is really based on the context of each situation, each case. But at the same time, you need to keep in mind that it is a beneficial legislation, and in general the balance tilts in favor of the contract for service to the extent employment benefits are being denied. It kind of laid down certain principles on how should you look at contract for service or contract of service. So I think that's going to be quite an important guidance for us employment lawyers, as we will look to see more cases coming up. And India is on the verge of redefining its labor law system, where 29 federal level labor laws are being converted into 4 labor codes. We are expecting those to happen as soon as April. And that is going to be by far the biggest change that we've seen in the Indian employment law history. And we are all extremely excited as employment lawyers to see how things change as a result of the codification of Indian labor laws. With the sort of COVID lockdown and the online hearing, I do echo, Gerlin from Germany and Divya from UK, in terms of their points, whether this is really going to be the new way of life. It's really hard for us to say at this point of time, but hopefully as things unfold, it is at least good to see that, courts have geared towards an online system. And hopefully this will become a trend in due course. We do have challenges today, but for any new sort of arrangement, you see those teething problems. Hopefully with, the courts being forced to hear online cases since the lockdown, it's like being pushed into the pool and learning to swim. I think it's going to be something like that. But overall, over the years, I think this is going to benefit the legal system in India in a big way. And hopefully we will see more cases coming up electronically and being heard online. That's about me. And from India, over to you, Samantha. Thank you.
Thank you, Vikram, and we really appreciate your joining us at a very, very late hour for you. So thank you for your remarks and thank you for hanging with us. So next up, we have the Inter-Pacific Bar Association, and we have Federique David. She is the chair of the Inter-Pacific Bar Association Employment and Immigration Law Committee, and she is doing double duty today, introducing her bar organization as the chair, and also she's speaking as well. So I will turn it over to you, and as we call her affectionately, Fred from Paris.
Thank you very much, Sam. And thank you also, Vikram, to be there at such a late hours. Representing here the Inter-Pacific Bar Association, I've heard that the session would be recorded, which will help most of the members of my association to be able to have a look at what we've done because of the time zone. So basically, the Inter-Pacific Bar Association was created 30 years ago in Japan. It's an international organization for lawyers and in-house lawyers, and it's mainly Asia and Pacific focused. It's a multi-matters association. There is 24 different committees, the Employment and Immigration Committee being part of it. We have around 1,400 members so far in 65 jurisdictions around the world. So all year long, we're doing, as I guess everyone is doing for the time being, so webinars for the time being. But usually we're organizing local events in every jurisdiction we have, with an annual highlight, which is the time of the year we all really like, meaning being able to meet in person together. Of course, as everyone, it hasn't happened since a year, but we're really longing to be able to meet together in several parts of the world. There will be a conference in Shanghai in 2 months. And we will also have a full live conference in June. After that, COVID depending, we will be able to meet in Japan and in Dubai. Basically, we have a committee which is the Employment and Migration Committee with around 120 members from 30 jurisdictions worldwide. And we're also organizing webinars and meet each other at the conference when we can, of course. So our value for each of the topics we are talking about would be to have an international focus, and that would allow us to think out of the box of our own jurisdictions and define the best practices. We really like to be together to achieve panels on many topics, but also we like to be very serious on social events, of course, as you will do. So turning back to COVID and litigation, I've been asked to speak for France, which, you know, employment and France, it's a very long story of love and hate, as everybody knows. So basically, on a practical matter, on the process, life have not really changed in courts. The only thing that was really a game changer was that during the first lockdown, when we were really strictly locked down for about 3 months, all of the courts were closed. So basically, as where that was described, for example, in Ireland, I mean, the courts have, you know, a real backlog to deal with. I hope that's going to be dealt with smoothly over the next, let's say, 2 to 3 years. As in India, we have a history of, you know, having very long process for hearing. It is really common to have, you know, you just file in court and then you would just be heard 1 to 6 months after that for the preliminary hearing, and then maybe a year after that, and then there's an appeal, and it's going to be 2 years about that, after which you have a final decision if it's not going to the Supreme Court. So it's a bit long. And at the same time, I've heard in England, for example, an example of a hearing of a 3-week duration. That would never happen in France. Basically, you have to file your evidence and your written pleadings, and then you will have a hearing where you'll have 20 to 30 minutes to plead the case for each party. So that's a big difference from what I've heard. What's not different, I mean, another difference is that it is really seldom that we can bring witnesses in court. I'm, you know, a 30-year experienced lawyer, and it only happened to me twice in a case. So it's really not something we had to deal with. So as I said, except that we have to wear masks and there are plexiglass, you know, walls, and that a seat out of 2 would be banned to sit on. There's no real difference in our lives in the process of litigation. There will be definitely something really changing. That would be, you know, the subjects that will probably be discussed. One of the very important one would be health and safety, because, you know, more and more in our practice, we have some cases that are not in litigation yet, but, you know, employers reporting that people insulated in their own home with, you know, difficulties to cope with technical issues, and the fact that they're really working remotely and feel really lonely. And there might be some cases where the liability of employers would be called in court because that insulation and the COVID context has a very important, a really important repercussion on the health and safety of the employees. So I've talked to some elected representative of employees, and they act as the Health and Safety Committee, and they really confirm that more and more, as I said, it's not in litigation stage yet, but more and more there are some discussions between them and the employees on that aspect. So we need to really stay focused on that and make sure that, you know, our clients, employers are really taking care of that. There would be also something on the health and safety aspect that would be the workload, because it's very difficult to monitor what the employees are doing. Are they working a lot? Are they not working? So in France, there's an obligation for the employer to monitor the working time and make sure that the employees are not working too much for their own health. So that is something that we will definitely see, you know, with the new context, and it's going to be very interesting to see what the judges would stand for. So there's going to be also probably lots of litigations regarding the monitoring of the vacation days. I recently had a case a few days ago where the employer has indicated that one of the employees went AWOL. They really don't know where they were, and there were no sick note and no vacation. So all of that is going to be new in terms of bringing proofs before the court. And I think another, and that would be my last point, another issue that we will probably see in the future would be that the French government has really pushed on a furlough system. And I've heard a lot of abusive views of it from employers, and there's lots and lots. It's not a Me Too one, but it's a kind of a movement where employees are saying that I was on a furlough system, and at the same time, my employer asked me to work. So I think that's going to be the kind of topics that we will have to cope with in the future. Thank you very much, Samantha.
Right, great. Thank you, Fred. And I also appreciate your being on the subcommittee that plans this webinar as well. So thank you for that. You've actually done triple duty if I also count the planning of the webinar. So thank you. So last but certainly not least is the American Bar Association. And as you all know, in case you haven't realized yet, I'm chair of the ABA section of labor and employment law, and I'm a partner at Shepherd Mullen in Los Angeles, and I practice law on the management side, so I represent employers. And just a little bit about the ABA, because I know we are running short on time. The ABA was founded in 1878, and it's committed to advancing the rule of law across the United States and beyond by providing practical resources for legal professionals, law school accreditation, model ethics codes, and more. Membership is open to US and non-US attorneys. The ABA section of labor and employment law has over 20,000 members, many of whom are non-US attorneys, some of whom are actually speaking at this webinar today, which I really appreciate. The section's members represent all constituencies, including employers, unions, employees, neutrals, academic, and the government. And all of our members are encouraged to participate in our committees, which produce in-person conferences, webinars, and publications. I'd like to introduce my dear friend and colleague, Eric Barnum. Eric is a partner at Baker & Hostetler in Atlanta. He is a phenomenal trial lawyer with experience in all aspects of employment law. He serves on the governing council of the ABA Labor and Employment Law section, as well as holding leadership roles in other bar organizations. He has too many awards to mention right now, but they are numerous, I assure you. And he is a go-to speaker for the ABA section of labor and employment law, as well as other bar associations. And I appreciate that as soon as I sent him a text asking if he would speak on this webinar, he immediately responded back on a Saturday saying yes. So thank you, Eric, and the floor is yours.
Thank you, Samantha, and thank you to the ABA for putting on this webinar. Thank you to all of my fellow presenters. I've enjoyed hearing from all of you as practitioners in labor and employment law. It's interesting to hear what you all are experiencing. A special thank you to my friend Samantha, who is the chair of the section of labor and employment law of the American Bar Association. Samantha, you are a tremendous leader, you are a dear friend, and you are a groundbreaker, a glass ceiling breaker. So for those of you who don't know, Samantha is the first African-American woman, and I believe the first woman of color, to chair the section of labor and employment for the American Bar Association. So thank you, Samantha, for your leadership. I want to spend a few minutes, I know our time is short, but I want to talk a little bit about litigation in the United States, employment litigation in this time of COVID. And I want to kind of strike a balance between litigation and advice and counseling, and how those things have evolved over this period of the COVID-19 pandemic and how they've changed for all of us. And so a couple of things I just want to kind of level set for everyone. most people will know this, but in the United States, our system of governance, our very politics, if you will, makes the practice of employment law in COVID-19 uniquely difficult, I would say. Many of you might be familiar with the notion of states' rights here in the US. That means 50 states get to decide its laws and how it's going to go about affecting those laws, including how the courts will operate. And by the way, that doesn't include the federal system, which is 11 different circuits. And within those 11 circuits, there are multiple district courts. And so we're literally talking about hundreds of courts across dozens of court systems and trying to keep all of those balls in the air. I smiled when I heard Ryan from Northern Ireland describe one building and 9 judges, and I thought what I would give to only have to deal with 9 judges. But such is not the case. And then, of course, there's the politics. And so I don't know if all of the viewers have heard, but here in the United States, there's a bit of a political divide. And so that makes things even more complex. So let me just walk through some of the issues. First, I want to talk about the difficulty of advising clients in this COVID-19 environment, and particularly as a defense lawyer myself, advising clients with multi-state operations, but the same would apply if you were a plaintiff side or employee lawyer here in the US, or if you represent unions, or if you're management like Samantha and me. We are dealing with employee rights issues, and particularly privacy rights and health issues. We have the Health Insurance Portability and Accountability Act, or HIPAA. And HIPAA is very specific about what employers can and cannot share with managers and supervisors around private health and medical information for workers. And so we're navigating the HIPAA issues on a state and on a federal level when it comes to COVID exposure, contact tracing, and how employers and workers have to manage those issues, and when one might violate HIPAA laws on both a state and federal level. Last year in March, April, and May, many workers and employers were dealing with layoffs, mass layoffs that came about as a result of the economic fallout of COVID-19. And so understanding the impacts of those layoffs and those reductions in force. Again, here in the US, we have lots of laws. There's a saying, we are a nation of laws. Well, we have lots and lots of laws. And so we have what's called a WARN Act, which is that's the Worker Adjustment and Retraining Notification Act, or WARN. And then many states have what are called mini WARNs, or smaller WARN acts. And so many employers are having to deal with grappling with all of those issues and understanding all of the WARN Act issues. There are return to work issues that we've been dealing with as different states come back to work, and the timing of those depend on the state legislatures and when governors will and won't open up the state. There are return to work issues now. Annalisa talked about vaccinations. And so many of us are dealing with laws around vaccinations and when employers can and cannot require workers to be vaccinated, and what are essential workers and when those workers can come back. Many of you talked about, many of the speakers before me talked about the court system and the court operations. I've alluded to that and the number of different court operations and procedures. We have a major backlog here in our courts. We have a criminal justice and a civil justice system here in the US. And under our Constitution, criminal defendants are guaranteed a fair and speedy trial, which means that all criminal dockets take precedence over the civil dockets. So if you're an employment lawyer, all of your cases are being moved to the back of the line for criminal cases. And even when a criminal case has been filed later than your employment case, that criminal case constitutionally takes precedence over your civil case. And so the backlog is significant. We're not yet into reincarnation phase, but certainly we have a backlog of cases. And then many courts are pushing employment cases to alternative dispute resolution and making sure cases don't even come before the court. And then finally, and I'll make this point last, Dia talked about remote litigation. We're seeing that explode by necessity. It's also difficult to have hearings here in the US because different courts, whether it's state or federal, have different technology capabilities. The bandwidth is often very different. Our federal judges have lifetime appointments. Some of our judges have been sitting on the bench for quite a while. And even our younger judges, not every judge is as comfortable with technology as practitioners might be. Practitioners aren't as comfortable with technology as many of our judges and the courtroom staff. So without any national response to COVID-19 and the pandemic, the only certainty has been uncertainty. So that's what life is like in the US practicing in the time of labor and employment law. So I thank you for your time, and back to you, Samantha.
Thank you, Eric. I really appreciate you, your comments, and thanks so much for again, agreeing to speak. Some final words. I'd like to thank the other planning committee members, the subcommittee that put together this webinar. Sal Alagaratnam from Malaysia, who is co-chair of the IBA Employment and Industrial Relations Law Committee, as well as a leader in the ABA L&E section's Outreach International Lawyers Committee. Melanie Crowley from Ireland, who is co-chair of the L&E section's International Committee. Danny Coffer from Canada, who serves on the Governing Council of the ABA L&E section. And Marianne Parker from the United States, who co-chairs our Outreach International Lawyers Committee. So as you see, we're well represented at the ABA and really appreciate collaboration with lawyers from around the world, which is why we were particularly pleased to collaborate with the phenomenal leaders and chairs from the bar associations that participated in this webinar. Thank you to all of the chairs for your collaboration, which I know will continue. Thank you to the speakers from all of the bar associations. On behalf of all the chairs that are present that put together this webinar, we'd like to thank everybody for attending. And please feel free to reach out to any of us for suggestions for future events and programming, which we hope to continue. And we look forward to seeing all of you at our next events that we put together. Thank you. Be well.